hit with different things in the mail, maybe a summons, maybe you guys are getting hit with just different letters and where they're threatening to garnish one's wages. If that is you guys, go ahead and drop in the comment section at 3. And we're gonna go ahead and wait for people to stream in. As we're waiting, let's go ahead and share one thing in the chat box that we're all grateful for. Let me go ahead and share this in my Discord as well. Let me let everybody know that we are alive. All right, much blessings to everybody tuning in. So we're gonna get right into the information. Thank you all for your time. Thank you all for tuning your time. Thank you all for tuning in, for aligning yourself with this information, with this channel, and everything that I'm about to cover here with you guys today. So I'm super grateful. I've got some things that I want to cover with you guys, and that's how to sue these debt collectors, right? So we're gonna hop right into it. We're gonna waste no time, because time is of the essence, and time is truly, our greatest asset that we have. I've been able to step into the investing space, heavily, launched a private equity fund over the past year, and it's really showed me that yes, these assets are amazing, but the greatest asset that I always have is time. And so I want to make sure that with your guys' time as well, I'm here being clear, being direct, and helping you guys get what you guys are seeking and looking for out of this information. So without further ado, as you guys are streaming in, feel free to just drop in the chat box something that you guys are all grateful for. I'm grateful for all of you guys being here. I'm grateful for, the shift of the energy. I'm grateful for the new year, stepping into the lunar new year and us stepping into the year of the fire horse, where we haven't had this in over 60 years. And this is a year of transformation. This is a year of taking action. And this is a year of all of your dreams and aspirations truly coming to reality with you guys taking action and putting in work. So today we're gonna talk about how to sue these debt collectors. I hope that you guys are all able to go out and get the success that I've been able to do in this space. And I've shifted from helping individuals, and doing for others, and now showing others how to do for self, because I believe that, if you teach a man how to fish, you can feed him for a day, or if you fish for a man, you can feed him for a day, but if you teach him how to fish, you can feed him for a lifetime. So I'm looking to show y'all how to fish. I'm looking to show you guys how to do for self. I believe that's where the true empowerment comes. So when it comes to suing these debt collectors, there are 5 steps I want you guys to make sure that you guys are all taking. And those 5 steps are going to be, number 1 being to identify the creditor. So who is the original creditor? I want you guys all taking notes, because note takers are money makers, right? They've said that you've only are able to retain about 70% of the information that you guys hear if you guys do not take notes. And so we want to make sure that we're getting, all of that information being able to be retained by us being able to take those notes. And now after we've taken those notes, we're able to retain it a lot more. Now that once we've retained it more, we can take action and be more clear on what it is that we're looking to get done. And this video is going to be uploaded, so make sure to drop likes, make sure to share in the comment section once you guys do get the results of you guys going out and suing the debt collector. So step number 1 is to identify the creditor, right? We want to identify where this, is originating from. Who is the original creditor? Do they have an arbitration agreement? Within that contract that we have with the original agreement, do they have an arbitration agreement? Because if so, and if they send it to a third-party debt collector, that is a breach of contract, right? So that's step number 1. Step number 2 is to the creditor's notification of the debt of sale. So I want you guys to verify whether the creditor provided you with the notification regarding the sale of the debt. So did you get anything that notified you that, we're gonna sell the debt to this third-party debt collecting company? Or did this third-party debt collector just have a whole, did it just randomly pop up on your report? You knew nothing about them. You knew that there was no communication between the original creditor and you showing or stating that they were going to send it over to this third-party debt collector, because that is what they do time and time again. And so you got to have that notice of debt sale from the original creditor. And then step number three is the debt purchase notification. So it assesses whether the debt collector has duly informed you about the acquisition of the debt. So they must once again notify you. This goes hand in hand with permissible purpose. If we look into 15 USC 1681B, right from the initial reporting of anything really on one's consumer report, they must have written consent from you, the consumer, or court jurisdiction. All right, and then we got step number 4 is to validate the debt amount. This is what we're going to cover a little bit today, is debt validation. This is 15 USC 1692G. I want you guys to be educated on where to go look for these. So all of these codes I'm, expressing to you guys can all go out and be able to look up every single one of these codes yourself as well too. Step number 5 is the information acquired by the debt collector, right? I want you guys to understand what information about you the debt collector has obtained through their purchase. What we're covering right now, what I'm going over is just one of our ebooks that we've dropped for you guys, throughout the past. This is something that is active within YBC University. So if you guys are looking to get access to these, like, where are you, getting this information from? There's all information that I have here in the office. I'm simply just going through the ebooks that we've drafted up over the years for you guys to be able to go out and take action on each and every single one of these. Okay, so to effectively handle a debt collector, it is crucial to begin reviewing the original agreement, because going through the agreement, once again, you guys are going to see, well, if there's an arbitration agreement, well, we should have gone through arbitration first, before any information was sold or even talked to any other, company in regards to them coming and collecting on their behalf. Second, they've got to send you over something called a 1099-C form showing that they terminated the debts, showing that they discharged the debts. Or the cancellation of any debt is filed through a form called a 1099-C form. So you guys all should have received or request, if you have not, that 1099-C form. All right, in the event that you do not possess a copy of the agreement, there's a convenience database available to you guys all on the CFPB's website. So you guys can go to CFPB database, credit card database, whatever that may pertain, and they'll have the database for just about every single credit card, agreement that you guys could think of or fathom. Credit card being one's social security number, right? That's the true definition and pursuant to 15 USC 1602. So I want you guys all to go acquire, if you do not already have that agreement, go look into the CFPB's database. And so once you've acquired the agreement, I want you guys to focus on these key elements that I'm going to cover here. All right, I've got a couple for you guys to cover. So number 1 is the permission to sell the debt. I want you guys to determine whether the oh, that's not bad. So the permission to sell the debt, did you guys give them permissible purpose? Determine whether the agreement explicitly granted the creditor permission to sell the debt or provided any indication of the intention to do so. So did they express that within their agreement? Did they even mention any other company, who they would be selling to, how they would be selling, or when they would be selling? If not, that is a violation and a breach of one's contract. And then we've got the dispute resolution. I want you guys to pay attention to the section of the agreement that outlines how disputes should be addressed if any agreements arise between you and the credit card company. So this is what I'm referring to with you going through and stating and going over and finding that arbitration agreement, because it states very clearly that if there is any disagreement, right, if you're looking to dispute, and the dispute resolution ought to be handled through arbitration. Well, why are you going through and furnishing my information and selling it to a third-party debt collector and having them collect on your behalf? That is very much fraud within its finest. That is a invasion of one's privacy. They're not able to go out and invade into your privacy and just go out and sell your information to a whole third-party debt collecting company. And understand that anybody can go out and start up a third-party debt collecting company. So after you've reviewed the agreements and identified the designated channels for the disputed agreements, our next step is to determine the foundation where these disputes will be built. So Thus, we need to rely on something solid. This is precisely why I asked you to examine the agreement beforehand. Now let's proceed to assess your report and see if we discover any relevant information. If you were unable to uncover anything in the previous steps, there's no need to worry, as this will make every effort to identify pertinent details at this stage. All right, so we're covering, for those that are just tuning in, welcome, much blessings. So make sure to get the likes up. We are going over one of our ebooks on how to sue debt collectors step by step. So I just want to read off this for you guys. I don't need to overcomplicate it. You know, the system, there's proof in the pudding. It's worked time and time again. So when examining your guys' consumer reports, here's a couple things to look for. Number one, the inaccurate reporting. So I want you guys to check out the debt collectors may inaccurately report information to the consumer reporting agencies, such as inaccurate balances, payment statuses, delinquency dates. Right? These are all things that are inaccurate, reporting. And in accordance to the FCRA, the congressional findings, this is Title 15 USC 1681. Right, so 15 USC 1681, right then and there, we'll be able to find the banking system is dependent upon fair and accurate credit reporting. If we think about what it means to be dependent upon something, that means it cannot live without it. And so, meaning the banking system cannot live without fair and accurate credit reporting. So when we're speaking on accuracy, it must be 100% accurate. When we're speaking on fairness, it must be 100% fair, and that is up to you, the consumer, to define what is fair and what is accurate. So some things to look for, once again, for inaccuracies are things such as incorrect balances, payment statuses, or delinquency dates. So if they've got 30, 60, 60, 90, 90, these are inaccurate, right? It should be 30, 60, 90, 120, 150 discharged whenever they discharge it, right? So it shouldn't be 30, 60, 60. It can't be 3 months late and still be 60 days late. That's an inaccuracy, which is what they'll do time and time again. Outdated debt reporting. So debt collectors have limited window, where they have a limited window within which they can report debt to consumer reporting agencies, usually up to 7 years from the date of the delinquency. Reporting outdated debts beyond this time frame violates the FCRA. So we've got that 7-year time frame. This all comes from Deuteronomy 15, the book of Numbers. After the end of every 7 years, one must cancel the debts to one's fellow Israelite. And we've got failure to update information, right? If you've made a payment toward a debt or reached a settlement agreement with the consumer or the debt collector, they're responsible for updating this information with the consumer reporting agencies. Neglecting to do so can misrepresent your current payment status. And we've got double reporting, right? If they've reported things double, we've got neglecting debt verification. We've got omitting required disclosures. So I've got a letter for you guys that I want to go through and read over. So you guys can use this letter verbatim. Right, this is going out to the debt collectors. I'm writing this letter to formally dispute the validity of the debt being reported by your agency and to request immediate validation of the debt, as well as correction to the inaccurate credit reporting on my consumer report. Here's the account information. You can list the creditor's name, the account number, the date of the last activity, the amount in dispute. I recently obtained a copy of my consumer report, which revealed the presence of an account allegedly being collected by your agency. Upon careful review and analysis of the information provided, I have reasons to believe that there are inaccurate reporting of this alleged debt on my consumer report. As per the FDCPA and the FCRA, I'm entitled to receive validation of this alleged debt. I kindly request that your agency provide me with the following information. Are you guys all with me? Drop a 3 in the chat box if you guys are all with me. I don't want to move on to the next part if you guys are not with me yet. I want to make sure that everybody's gotten all of that letter. Drop a 3 in the chat box if y'all are with me. Who's with me? Who's with me? Okay. So here's the things that we're going to be requesting. We're going to be requesting, number one, the verification of the debt, the amount, including a debt breakdown of any interest. Number two, the copies of all documents providing that I am indeed responsible for this debt, such as a signed agreement or contract with the original creditor. Number three, verification that your agency is legally authorized to collect this debt on behalf of the original creditor. I also request that your agency cease all collection activity, including any reporting to the consumer point agencies until requested debt validation is provided and pursuant to 15 USC 1692 CC. I also request that your agency, okay, I already read through that. Please be aware that inaccurate reporting of this debt to the consumer point agencies is negatively impacting my creditworthiness and causing substantial harm in accordance with the FCRA. I hereby dispute the accuracy of this alleged debt and request that you correct any numerous information being reported to the consumer point agencies, including but not limited to incorrect balances, misrepresented payment statuses, inaccurate dates of delinquency. And I expect that your agency to conduct a thorough investigation into disputed debts and promptly provide me with the requested validation within 30 days of receiving this letter. If your agency fails to validate the debt or correct the inaccurate reporting within the specific time frame, I will have no choice but to exercise my right under the FDCPA FCRA to pursue all available legal remedies to protect my interest. Please communicate with me in writing only and provide all correspondence related to this matter via certified mail with the return of a receipt requested. This will ensure a documented record of our communication. Thank you for the immediate attention to this matter. I look forward to swift resolution and restoration of accurate consumer reporting. So then I want you guys to mail that out to the third party. The purpose of this letter is simply to request the agreements and the statements from both parties, which will be utilized to demonstrate their awareness of being bound by the original agreement between you and the original creditor. Ultimately, it all comes back down to the original agreement once again. So we want to request that from them. And we also want to get the tracking number and the receipt for future reference if needed, because I always state that court starts in the mail. All right, step number two is to apply for stuff, apply for different accounts, and check your reports again. Right, after that, after disputing or submitting your dispute letter, it's advisable to begin applying for various financial services or credit opportunities with the hope of receiving denials. These denials can serve as evidence of the harm caused to you. Approximately 1 to 2 weeks after mailing the dispute letter, it is recommended to review your credit report, specifically verifying that they have reported the alleged debt as disputed. If your debt collector has failed to update your report accurately. Step number three is the opportunity to settle. So when we encounter the term settle, our natural assumption is often that we are the ones making the payment. However, in this particular case, we're offering the opposing party an opportunity to settle before we proceed to arbitration. Right? So as I mentioned early on at the beginning, the goal and what's stated within these agreements is an arbitration clause. Right? I want you all to go to adr.org and go to the consumer registry, which you guys will be able to find any agreement, in terms of the arbitration agreement from any company that is regulated by the American Arbitration Association. And that is where things should have been handled if there was any disagreement. Therefore, your next step is to gather the agreement you previously reviewed. Let's see. You previously reviewed, okay, with these documents as exhibits, you will draft a pre-arbitration demand letter. In this letter, you'll give them a chance to settle the matter at a discounted rate before we initiate arbitration, warning them that the cost will increase if we proceed, because going through arbitration is going to cost them tens of thousands of dollars. So in this letter, you'll give them the chance to settle the matter at a discounted rate before we initiate arbitration, warning them that their costs will exceed. Make sure to highlight the section within the original agreement that stipulates disputes should be resolved through arbitration If the opposing party chooses to adopt a tough stance, we will provide the necessary steps for arbitration during, a specific webinar. We go over all of this as well too within YBC University. So this is the letter that I want to go ahead and share with you guys, and then after this, we'll go ahead and wrap it up. But this is a pre-arbitration letter. This is the power. If you guys have anybody that you guys are sending this video out to, tell them, skip to, minute 20 to get the sauce, because this is something that has given me the power time and time again without having to go to court, without having to even go through arbitration. And I've been able to get tons of settlements just from these types of letters right here. So this is just a template and outline. You want to specify every letter to your guys' specific case, but this is something that can help you guys tremendously. It states, I am writing this letter to present you with an opportunity to settle this dispute between us before initiating arbitration proceedings. It has come to my attention that your agency inaccurately reported information on my consumer report, leading to the denial of credit applications. And close with this letter, please find the adverse action letters as evidence of the denials I received based on the inaccurate reporting. As you may be aware, arbitration can be a costly and time-consuming process for both parties involved. In an effort to avoid unnecessary fees, expenses, and complications associated with arbitration, I'm extending the settlement offer to you. The settlement offer, the amount of whatever it is that you guys are seeking. This amount represents a discounted settlement in consideration of the inconvenience, harm, and negative impacts caused by the inaccurate reporting on my consumer file. It is essential to note that this offer is time sensitive and it is contingent upon your prompt acceptance. Furthermore, I would like to draw your attention to the original agreement between myself and the original creditor, which specifies that disputes are to be resolved through arbitration. I have attached a copy of the relevant section from the original agreement for your reference. In the event that you choose not to accept the settlement offer within the time frame of 30 days from the receipt of this letter, I will be left with no choice but to proceed with initiating arbitration. This course of action would entail additional fees and expenses for your agency, including the payment of my attorney fees. I believe that in both of our interests to resolve this matter amicably and avoid unnecessary litigation. Therefore, I strongly urge you to carefully consider this settlement offer and respond promptly. Please communicate your acceptance or any counteroffer in writing to the address provided below. I kindly request that you retain copies of correspondence related to this matter for future reference. Thank you for your attention to this urgent matter. I look forward to receiving a prompt response and achieving a mutually satisfactory resolution. Whew. So that is everything really in terms of